Well, hello, and can I welcome you to the first day of Christmas of the King's Chambers Advent Calendar. As you can see, we're taking it enormously seriously in terms of any legal submissions, and I have been asked to start off with the first day of Christmas. Unfortunately, there's no case about pear trees that we could find in the law reports. However, I have a case for you called Day against Womble Bond Dixon, 2020 EWCA CIV 447, a judgment of Lord Justice Coulson, which relates to the principle established in the case of Walpole against Partridge and Wilson 1994 QB 106. It's a Partridge case. It's a criminal case relating to an environmental prosecution, a prosecution by Natural England against the owner of the Edinburgh Wool Mill, Mr. Day, who owns an estate called Hayton estate up near Carlisle, which he wants to maximise for partridge shooting. Mr. Day had various contractors on his land, some of whom sought to put a road through an area called Gelt Wood, which is part of a triple SI, and to take out about 4 dozen trees from the wood and cause some degree of ecological damage to the woodland. Mr. Day was prosecuted before the Magistrates' Court, and his solicitors advised him to head on up to the Crown Court, it being an either way offence, where after legal submissions Mr. Day was told by the court that this was a strict liability offence, so he pleaded guilty, but he challenged the culpability, challenged the way in which the prosecution was put, so the 4-day Newton hearing looking to see how culpable he actually was of these offences. Well, after 4 days of argument, the court concluded he was very culpable, and he was fined £430,000 for the 2 offences in order to pay £457,000 of prosecution costs. The case then went upstairs to the Court of Appeal, challenging the proportionality of the costs, and the Court of Appeal said, nah, they were perfectly fine, thank you very much. So Mr. Day then sought separate legal advice and sued his former solicitors, arguing a couple of things. He argued that they should have run an argument of abuse of process, and that they shouldn't have told him to take the case upstairs to the Crown Court, because the maximum sentence in the Magistrates' Court was only £20,000 per offence, which would have meant a maximum sentence of £40,000, not £430,000. Well, the Court of Appeal gave both arguments some short shrift. The principle of the Partridge case, which is one from a long line of litigation, is that it's a rule of law and a manifestation of public policy that a civil court should not be awarding damages to compensate a claimant for a disadvantage which the criminal courts have imposed on him or her by way of a punishment for a criminal act for which he or she was responsible, and that it's essentially a collateral attack, or a collateral attack on a subsisting conviction and sentence will be considered by the civil courts to be an abuse of process, and it should be struck out pursuant to the civil procedure rules. Well, Mr. Day argued that there was an exception to this, and sought to argue a series of different points, but Lord Justice Coulson firmly rejected those challenges, finding that the principle of illegality definitely applied, distinguished the Partridge case on the grounds that that involved a legal argument, in other words, some element of legal illegality and a failure to hit a deadline by firm solicitors. But in this case, this was a straight collateral attack upon a criminal conviction in the civil courts, which would not be tolerated by the courts. It's a case where it's worth a read for a number of reasons. Firstly, it's interesting. Secondly, it's got some language which is particularly choice from the bench. And let me give you paragraph 78 of Lord Justice Coulson's judgment as an example. He said, throughout his submissions, Mr. Stewart, that's the barrister acting for Mr. Day, referred to the test he considered applicable to the application to strike out, namely whether an intelligent 12-year-old child would understand why an otherwise arguable claim against the appellant's previous solicitor should be prevented at an early stage from going any further. It was unclear to me, said Lord Justice Coulson, what the source of this test was, but I'm happy to adopt it to summarise my conclusions. It seems to me that Mr. Stewart's putative 12-year-old child would appreciate quite quickly that it was sensible and necessary for the final decisions in criminal courts to be just that, final, and that subsequent satellite litigation, re-arguing points that could and should have been raised before, and which went directly or indirectly to undermine the conviction and its consequences, was inappropriate, a wasteful of resources, and likely to bring the law into disrepute. it's not a case where Mr. Day has done very well out of the legal system. But it's an interesting read, and it certainly tells you that the courts will, in appropriate circumstances, deal with environmental prosecutions in a very, very robust way. Thank you very much, and happy Christmas. Bye.